Section 4, Resolution of Investigating Prosecutor and its review. If the investigating prosecutor fi- finds cause find cause to hold the respondent for trial, he shall prepare the resolution and information. He shall he shall certify e- under each in the information that he or as shown by the record and authorized officer has personality examine the compliant and his witness the, that there is a reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof, that the accused was informed of the complaint and of the evidence submitted against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommended the dismissal of the complaint. Within 5 days from his resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor or to the ombudsman or his deputy in cases of offense cognizable by the Sandigang Bayan. In the exercise of its original jurisdiction, they shall act on the resolution with 10 days from their receipt thereof, and shall immediately inform that the parties of such action. No complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor of chief state prosecutor or ombudsman or his deputy. Where the investigating prosecutor recommends that dismissal of the complainant but his recommendation is disapproved by the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy on the ground that probable cause exists, the latter may by himself file the information against the respondent or direct another assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation if upon petition by a proper party under such rules as the Department of Justice may prescribe or mutupo the Secretary of Justice revise or modifies that resolution of the provincial or city prosecutor of chief state prosecutor. He shall direct the prosecutor concerned either to file the corresponding information without conducting either preliminary investigation or to dismiss or move for dismissal of the complaint or information without notice to the parties. The same rule shall apply in preliminary investigation conduct by the officer or the office of the ombudsman. Section 5 resolution of investigating judge and its review. With 10 days after the preliminary investigation, the investigating judge shall transmit the resolution of the case of the provincial or prosecutor or the ombudsman or his deputy in cases of offense cognizable by the Sandigang Bayan in the exercise of its original jurisdiction for appropriate action. The The resolution shall state the findings of fact and the law supporting his action together with the record of the cause, which shall include a the warrant if the arrest is by virtue of warrant, b the affidavit, counter affidavits, and other supporting evidence of the parties, c the undertaking of belief of the accused and the order for his release, d the transcript of the proceeding during the preliminary investigation, and the order of the cancellation of his bail bond if the resolution is for the dismissal of the compliant within 30 days from receipt of the records. The provincial or city prosecutor or the ombudsman or his deputy, as the case may be, shall review the resolution of the investigating judge on the existence of probable cause. The ruling shall expressly and clearly state the fact and the law on which it is based, and the parties shall be punished with copies thereof. They shall order the release of an accused who is detained in no probable cause in found against him. Section 6. When warrant of arrest may issue: a by the regional trial court within 10 days from the filing of the complaint or information. The judge shall personally evaluate the resolution or the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly failed to establish probable cause. If he finds probable cause, he shall issue a warrant of arrest or a commitment or order if the accused has already been arrested, pursuant to a warrant issued by the judge who conduct the preliminary investigation, or when the complainant or information was filed pursuant to the Section 7 of the rule. In the case of doubt on the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from the notice, and the issue must be resolved by the court with 30 days from the filing of the complaint of information. B. By the municipal trial court when required pursuant to the second paragraph of section of the rule in the preliminary investigation of the case failing under the original jurisdiction of the Metropolitan Trial Courts, municipal trial court in cities, municipal trial court or municipal circuit trial court may be conducted by either the judge or the prosecutor. When conducted by the prosecutor, the procedure for the issuance of warrant of arrest by the judge shall be governed by paragraph A of this section. When the investigation is conducted by the judge himself, he shall follow procedure provide section 3 of the rule if his findings and recommendation are affirmed by the provincial or city prosecutor or by the ombudsman or his deputy, and the correction spending information is filed, he shall issue a warrant of arrest. However, without waiting for the conclusion of the investigation, the judge may issue a warrant of arrest if he finds, after an examination in writing and under part of the complaint and his witness in the form of searching question and answer that a probable cause exists and that there is a necessary of planching the respondent that under immediately custody in order not to frustrate the ends of justice. Ends of justice. Uh, C. When a warrant of arrest not necessary, a warrant of arrest shall not issue in the accused is already already detention pursuant to the warrant issue. The municipal trial court in accordance with paragraph B this section or if the compliant or information was filed pursuant to the section 7 in this rule or it's for the offense penalized by fine only the court shall then proceed in the exercise of its original jurisdiction. May sir.